this is a hybrid panel, so some of us here in the room in person, some folks online, both presenters and viewers alike. Let me just sort of tee it up real briefly and a very super fast introduction of our speakers. So the issue, as you may know, is the Supreme Court is poised to decide what could be a major Clean Water Act decision in Sackett v. EPA. It was the first case argued at the start of this term. We don't yet have an opinion, and part of today's discussion is for us to think about what's at stake and then strategically how advocates might approach this issue going forward in preparing for the decision that is yet to come. So we're in this pregnant moment waiting to see what's going to happen and hopefully preparing as best we can. We've got 4 of us here to talk about it. We're going to lead off with Robin Craig at USC School of Law here in the room. Professor Craig is the Robert C. Packard Trustee Chair in Law at USC. And I will say, she said I shouldn't say this, but I'm going to say it anyway. I would say she is the go-to expert in the country on the Clean Water Act, certainly on the all-star team of Clean Water Act scholars that you want to be talking to. So we'll have Robin will tee us off, sort of laying the groundwork and setting the stage so that we're on the same page on these issues. Then we're going to go to the Zoom room and we're going to hear from Steph Tai. Steph is a professor of law at Wisconsin School of Law and has authored an amicus brief, not just in Sackett, where they represented the scientific societies, but also in, I'm sure in many other cases, but I'm thinking of County of Maui versus Hawaii Wildlife Fund, another blockbuster Clean Water Act case where really remarkably, it almost never happens that the Supreme Court cites an amicus brief, especially an amicus brief that's not from the Solicitor General's office, but they cited Steph's brief in the County of Maui case. So we'll hear from Professor Tai, and then we're going to go to Jannette Brimmer, a senior attorney with Earthjustice, and again, a national expert on the waters of the United States issue, WOTUS, for those who are in the know. Jannette also authored an amicus brief in the Sackett EPA case. Her team represented the Menominee Indian tribe of Wisconsin. And Jannette has been a leader, an absolute leader as an advocate on WOTUS issues nationally, and actually was part of how I got brought into the case as well. I am Cale Jaffe. I'm a professor of law at the University of Virginia, where I direct the environmental law clinic at UVA. Our clinic authored an amicus brief also in Sackett, where we represented the Idaho Conservation League. So you've got 3 of us who are sort of engaged in Sackett as amici, and then Professor Craig, who is the nation's expert on the Clean Water Act, to really set the stage for us. So without any more, let me turn it over to Professor Craig.
Thank you. All right, thank you, Cale. I actually prefer to come in with sort of lowered expectations, but there we go. All right. So as Cale mentioned, my job is to set the stage for those of you who have not been living with this issue for the last 2 decades, as some of us have, catch you up on the overview of waters of the United States and the U.S. Supreme Court. I will mention in passing, we decided not to go into the regulations, but there is a parallel, complex, convoluted story about the back and forth of regulations, which in part Sackett may make moot, which is one reason we're not going into it. But let's just say it got complicated enough with the regulations that at one point, not even the EPA knew which regulations applied in New Mexico. All right, so that gives you some idea of the depths that this got to. All right, basic, where do waters of the United States actually fit into the Clean Water Act? I like to emphasize that this is one subpart of one element of Clean Water Act jurisdiction, because that fact tends to get lost in all of the debates over waters of the United States, particularly with respect to farms who have all sorts of exemptions under other facets. But the Clean Water Act's basic prohibition is laid out fairly early in the act, and it says, except as in compliance with the act, the discharge of any pollutant by any person is unlawful. So that's what triggers the act. You're discharging a pollutant is really easy to be a person, so that rarely comes up as an issue. But you're discharging a pollutant. Where that gets complicated is the act then goes on to define discharge of a pollutant. So the discharge of a pollutant or the discharge of pollutants means any addition of any pollutant to navigable waters from any point source. So you add person, there's your 5 elements for one prong of it. And any addition of any pollutant to the waters of the contiguous zone or the ocean from a point source other than a vessel or other floating craft. I like to throw that second half in because the ocean is part of the Clean Water Act. However, the ocean is never a waters of the United States issue. It's clearly federal. That has never been in question. The ocean is not at risk from any of this. All right, so that is the definition. So like I said, that first prong A, you have to have an addition of a pollutant to navigable waters from any point source by a person. That's how you get into the Clean Water Act. Okay. What we're worried about is one phrase in there, navigable waters, which is also defined, although not well enough. Okay. So water subject to Clean Water Act, navigable waters is defined to be the waters of the United States. So 4 levels in, we finally get to the phrase that's causing all the problems, waters of the United States, including the territorial seas. The territorial seas defined by reference to some international convention, but they're the first 3 nautical miles of the ocean. Again, ocean not at issue. But what are waters of the United States? That's what the debate has always been about. Early history of the Clean Water Act, it was generally assumed on the basis of some pretty good legislative history, in my opinion, that waters of the United States went to the limits of the Commerce Clause. If you could get it in under the Commerce Clause, it was a water of the United States. That's a very broad definition. And what the US Supreme Court has been doing since about 2001 is narrowing the scope back down, all right, or narrowing the scope down from, like I said, what I think Congress originally intended. But importantly, all of the waters of the United States decisions from the US Supreme Court come in the context of Section 404. So if you don't know the Clean Water Act, once you trigger it, the way you comply with the Clean Water Act is to get a permit. And you're either getting a Section 402 National Pollutant Discharge Elimination System permit, or you're getting a Section 4 dredge and fill permit. Section 402, the NPDES permits are factories with pipes. That's the quintessential vision of an NPDES permit. The classic industrial polluter that Congress had in mind when it was putting the 1972 version of the Federal Water Pollution Control Act amendments together. But that program, the Supreme Court likes to keep broad. How do I know that? See, Maui County has mentioned 2020, the United States Supreme Court comes up with a very broad definition of the act's applicability, not involving waters of the United States. They were actually defining from, I kid you not, but come up with a very broad definition of waters or of Clean Water Act jurisdiction in the NPDES context. That's classic Supreme Court. They like Section 402. They hate Section 404. Okay. 404, like I said, dredge and fill. What are you dredging and filling to do? Oh, develop private property. Hence the conflict. All right. If you're into private property rights, as the Supreme Court has been for quite a while now, you're not going to like 404, or at least broad jurisdiction for 404 all that much. So like I said, the interpretations, I'm going to go through these fast and then I'll break them down a little bit more. First of all, 1985, Supreme Court decided the Riverside Bayview case. Important thing about the Riverside Bayview case, 9-0. Adjacent wetlands, or wetlands adjacent to traditional waters of the United States, meaning traditional navigable waters, i.e. you actually can float a boat on them, are included. So 9-0. 2001, we get Swank, Solid Waste Agency of Northern Cook County versus U.S. Army Corps of Engineers. 5-4 decision. You cannot get to isolated waters, isolated wetlands on the basis of a gloss called the migratory bird rule. Basically, the Army Corps and the EPA asserted, if a migratory bird lands there, we got it. It's jurisdictional water. And the Supreme Court said no. That's the narrowest reading of that case, by the way, but that's what they actually decided. And then 2006, we get Rapanos 414 decision. Pick your test, and this is the legacy we are living with, and that Sackett may resolve or may make worse. Okay, and that's one of the great uncertainties of this case. So United States versus Riverside Bayview Homes, again, it involved a wetland that was pretty adjacent to a traditionally navigable water, Lake St. Clair. No one was fighting about that. It had a little bit of a berm in front of it. But like I said, 9-0, the Supreme Court said, hey, what's a water and what's land is kind of ambiguous in a lot of circumstances. We're going to defer to the Army Corps and the EPA. We need to regulate these adjacent waters if we're actually going to clean up pollution in the navigable waters. Otherwise, there's a gigantic loophole in the Clean Water Act. You just dump everything in the wetland right next door and get yourself out of regulation. So 9-0, adjacent wetlands are jurisdictional waters. Solid Waste Agency of Northern Cook County versus U.S. Army Corps of Engineers actually involved a sand and gravel mine that had filled in with water. The Army Corps originally said it wasn't jurisdictional, and then somebody pointed out, oh, but migratory birds are using it. So, okay, that makes it jurisdictional. It's covered by the Clean Water Act. Solid Waste Agency appealed that. And like I said, the Supreme Court said 5-0, no, it's not connected to larger water. So that hydrological connection was what was important in Riverside Bayview, and it's what's going to be important going forward. And then, like I said, Mr. Rapanos there causing all sorts of grief. Pretty well documented. If you're interested, the Community Rights Council put together a great historical series of photographs showing what he was doing to his property. But it clearly had wetlands on it. He was told by the Army Corps, don't fill them in. He kept filling them in anyway. You can see the end product completely filled in. He got in trouble, ended up going to the U.S. Supreme Court. Court splits 3 ways with no majority opinion. So the Rapanos split. You have Justice Scalia's plurality, which said wetlands are covered when they have a direct surface water connection to relatively permanent, relatively navigable water. So you have to have that direct surface water connection to relatively permanent navigable waters. Interestingly, in the resulting circuit split from the Rapanos opinion, no court of appeals has followed just the plurality. Justice Kennedy, all by himself, said waters are covered when they have a significant nexus to the traditionally navigable waters, such that pollution of the smaller water can affect the chemical, physical, or biological integrity of the larger water. Okay. All by himself, he created the majority test as adopted by the federal courts of appeal. So all courts that have addressed the issue use at least Justice Kennedy's test. Some of them use only Justice Kennedy's test. So if nothing else, reflects the great power of Justice Kennedy when he was on the court to dictate the test. Justice Stevens in dissent, there were 4 in dissent, said, hey, it's broader. It should go to the limits of the Commerce Clause. We lost that battle in Swank. So we're not going to win a broader test. So we tell you what, Any water that meets either of the other two tests is a jurisdictional water. So you like Justice Scalia's test, use that. You like Justice Kennedy's test, use that. We're fine with either one. The either or approach. If you count noses, that means you've got 5 people who support Justice Kennedy's test and 8 people who support Justice Stevens' test. And the circuits who can count noses say, okay, either or it is then. All right, so that's our current circuit split. It is an unresolved circuit split because we can get neither regulations nor a clear Supreme Court pronouncement. But that's the split. Is it just Justice Kennedy or is it the either or approach? Okay, that is what we go back to when the Supreme Court and the agencies can't get something else that sticks. That's the background. All right, so Sackett versus EPA involves Priest Lake, Idaho. Again, Priest Lake, Idaho, navigable water. Nobody's debating that. I wanted to show you the property because this is so ridiculously close to Priest Lake. The fact that we're fighting about it is kind of bizarre. This is actually the Sackett's second trip to the US Supreme Court about this property. If you know your administrative law, their first trip established the fact that a jurisdictional determination is itself immediately appealable. And so they got sent back after establishing that principle, and this is the appeal. There was a lot of interim effort in there, but this is the appeal of that jurisdictional determination. These are some photographs that were a part of the Ninth Circuit's opinion, showing the waters that were originally kind of connecting up this property to Priest Lake. And the Ninth Circuit said, yeah, this is a jurisdictional wetland. Okay, we are deciding for real, this is a jurisdictional wetland using Justice Kennedy's test. So this is also the case where the Ninth Circuit announced fairly clearly, finally, that it was following only Justice Kennedy's test. And so the Ninth Circuit's analysis is worth laying out because there are several prongs in it that could get problematic for the Supreme Court. So the Ninth Circuit's significant and nexus analysis, the wetlands on the Sackett's property they're also filled in now, were adjacent to an unnamed stream 30 feet away and on the other side of the road that's tributary to Kalispell Creek, which flows into Priest Lake, a traditional navigable water. Moreover, the Sackett's wetlands are part of one of the 5 largest wetlands complexes along the 62-mile shoreline, and therefore these wetlands in combination significantly affect the integrity and water quality of Priest Lake. Okay? If you're thinking in terms of proximate causation, that's a long chain to connect those wetlands on the Sackett's property to Priest Lake. And notably, the district court just said, yeah, they're directly connected to Priest Lake. It's underground, but we know from Maui, underground's fine. So they're directly connected to Priest Lake. So the district court analysis is these are directly hydrologically connected wetlands to Priest Lake, which is actually the easier way to go about this case. The Ninth Circuit's analysis, like I said, is all over the place, and it's a long set of connections. All right, so the cert question that was granted in Sackett versus EPA is whether the Ninth Circuit set forth the proper test for determining whether wetlands is, that was the Supreme Court, waters of the United States under the Clean Water Act. So the question that we're going to go into is, what might the outcome be? And I'm going to start by giving a range of possibilities, some of which are less helpful than others, shall we say. So one possibility is the Supreme Court just said, yeah, the district court got it right. They're hydrologically connected wetlands, see that underground, we're done. We're going to skip the United Circuit's convoluted analysis. That would be the best of all possible worlds. The Supreme Court could start riffing on what counts as an adjacent wetland. That's well within the possibility. How do they have to be connected? How far away do they have to be? Are wetlands that are adjacent to tributaries, which is what the Ninth Circuit found, adjacent wetlands for purposes of waters of the United States? We could have a riff that way. We could just pick a Rapanos test and remand. Huh? We had those 3 tests. Supreme Court, if I'm going to put down a bet, I'm going to bet they go with Scalia. But they pick a test, remand, analyze it under the right test. All right. They could invent a new test, adding to the fun and games, and by the way, eliminating the circuit split in one fell swoop. In which case it would also be remand, analyze it again under the now pronounced correct test, which hopefully they do by a majority this time, at least. They could override or overrule Riverside Bayview. That's the worst of all possible outcomes. They overrule Riverside Bayview and say, nope, it's got to be a traditionally navigable water. So range of things the Supreme Court could do. Want to know where my personal bet is? My personal bet is they're going to announce a test and remand, but we'll see what they do. And with that, I've used up my time. So we'll pass it on to the people who have skin in them.
All right, I'm gonna end the screen share here so that Steph can go as whenever you're ready, Steph. Let you run it.
Thank you. I'm not gonna, and thank you, Robin, for laying this up so well. I'm not gonna initially screen share because I just want to talk about.
Hold on a quick second. I got to go back to. Oh, I've got to stop the screen share. Sorry.
Oh, it's.
I was. Oh, wait, no, I did stop it. Did we? No.
I did stop it.
All right.
I'm like, the
This is
screen
why we
share's
had
not.
technical.
So what
Okay.
is that you're going to, this is still on this, so you have to, let's back up, I believe, no.
No, we're getting there.
Sorry.
Okay,
So
in Zoom land, it's gone.
still on here for some reason.
For some reason, this maybe just shut down the PowerPoint.
Yes. That should help. You just need to hit escape, do PowerPoint. Oh.
Oh, go back to the PowerPoint.
Yeah, no, you should
So just
hit escape.
so what happens if I close that?
It was dragged
There we go.
over onto that.
Okay.
Oh, I see.
All right, we're good.
Okay,
You're
thank
on the
you.
screen. Yes.
all right. Thank you, Robin, for laying this up so well. I'm going to talk about sort of some of the scientific principles behind wetlands connectivity and also some of what the scientists that we presented before the Supreme Court. So one of the things, as Robin alluded to, is that, there can be hydrological connections that are not totally obvious on the surface. And these have been studied extensively, right? And so that's part of the sort of connectivity report that was put together by the Army Corps and EPA through expert advisory committees to establish some of the sort of regulations that are out there that we haven't talked about. The ways that they can be connected are a number of ways, right? So one thing, wetlands and streams can act as protection and habitat for fish, shellfish, and wildlife of the actual sort of navigable waters. They can also transform materials, especially nutrients and chemical contaminants, into different physical and chemical forms, again, affecting the actual kind of surface, sort of navigable waters. And they can be connected in sort of underground ways that are not just sort of a magic black box thing, but the scientists have actually studied and been able to model and sort of quantify. And so, for example, an individual ephemeral stream may contribute a small amount of water, organisms, and material to downstream waters in a given year, but the aggregate contribution over time might be substantial, and that too can be modeled. And human activities can affect these kinds of functions, right? Which in turn harm actual surface waters. There's been a number of hydrological studies on this. And so I just wanted to sort of present some of the sort of background behind the science of connectivity. I also want to talk about how this is not just sort of some kind of black box scientific magic, right? A lot of the ways that these kinds of models were established were through both the combination of theoretical science, combination of empirical science, and a combination of basically computational modeling. So basically, how does this all fit in? You've got theoretical science talking about the different types of theories of groundwater connections and understanding the different types of underground surfaces can lead to greater or lesser connectivity. The empirical background, right, is actual tracer tests. So this has been done in a number of different kinds of areas where you actually set forth chemical tracers to see the actual connectivity of particular wetlands to surface waters. And then the last part is developing these models. So these models are usually developed through a series of evaluating the different types of theories, testing them through empirical tests, and sort of coming up with basically algorithmic models to try to model that connectivity. And it doesn't end there. It goes through, and that model is then applied to particular types of wetlands to find out whether or not, you know, the modeled connectivity actually reflects the real life connectivity. And again, that's assessed through, again, additional testing. Now, this can't be done for every single, the empirical testing can't be done for every single individual wetlands, but it can be done in a broad enough sense so that as a scientific matter, we can understand the general sort of connectivity given the particular features of a particular site. So this is sort of just general background into how wetland science has developed over the years. By the way, I just want to say that, you know, I bow to Robin Craig. I am not, you know, initially a Clean Water Act dude. I'm really much more of a Clean Air Act person, but I am involved in a lot of scientific amici. And so that's where sort of I come into play. So like Cale mentioned, I represented with a number of individual wetland scientists and also water science societies. And this is really rare to actually get a number of sort of wetland societies to actually sign on to this. I worked, like I mentioned, I started off a lot of my scientific amicus work with Clean Air Act kind of issues. And it's harder to get actual scientific societies to sign on in the Clean Air Act context. It's much easier to get individual scientists, but they're much more cautious about what they say in amicus briefs, partly because there is such an attack on climate scientists. So I think this is a different context. There hasn't been that kind of political attack on sort of water scientists, but that said, this is sort of an aside for later. What I want to do is sort of share additional stuff about what we shared. So in our brief, we explained to the court how wetland science works, how it's developed, how hydrological connectivity is assessed. We explain that this is not black box magic, but rather a very iterative sort of process. And this was the same group of scientists and wetland societies that were the amici in Maui versus in the Maui case, right? So, so this was, we hope, persuasive because the Supreme Court has listened to us before. We'll see what happens with this. But what I wanted to show you, and here's where I start sharing screens, is the modeling that we presented to the court. So after a lot of this sort of background stuff into how modeling works, how the models are developed, what we then presented was an actual depiction of the loss of coverage that would happen should the Supreme Court rule for the continuous surface water connection test, which, you know, again, doesn't actually cover a lot of the ways in which sporadically connected wetlands can actually affect navigable waters, but instead, you know, is much more limited. We showed a number of different watersheds. So here's an example of the Rio Salado watershed in New Mexico, right? You can see the dramatic difference in coverage, right? The blue areas is a significant nexus test where a number of hydrological models suggest significant connectivity between various wetlands and navigable waters versus the surface water connection test. This is another example. This is the South Platte watershed in Colorado. You can see on the left, right, a significant amount of connectivity through a number of seasonal kinds of connections, a number of hydrological connections that are subsurface versus the continuous surface water connection test. The next one is Cottonwood watershed in Minnesota, which has on the left, you can see the significant nexus test provides a much larger kind of connectivity. And again, we explained that this connectivity is necessary to basically avoid pollution to surface waters versus the continuous surface water connection test, which would really leave absent a lot of areas that would be covered under the significant nexus test. And then the last one I wanted to show is the sort of Nanticoke watershed in the Maryland, Delaware area. This one is somewhat more, you don't see as dramatic a shift, right? But you still see a shift between watersheds or between wetlands that are covered under the significant nexus test versus a continuous surface water connection test. So at this point, I'm going to stop sharing and then just go back to talking about what's at stake. What we tried to do in our brief was explain not only the dramatic difference in coverage between the different kind of tests, hoping that these illustrations and models would provide sufficient support for this, but also to explain what's lost, right? If these areas are not regulated through a permitting program. What's lost is the ability to basically regulate all of the sorts of quality features that I mentioned that wetlands provide to actual surface waters, right? So you've got the sort of filtering features, you've got the flood protection features, you've got a lot of, in the ecosystem features, you've got a lot of different types of features that won't be protected if these types of these sort of non-continuous surface water connections are not covered under the 404 program. Moreover, we also explained, because again, these scientific societies came from a wide range of disciplines. Some of them were sort of were more focused on studying sort of subsurface connections. Some of them were more focused on sort of hydrological monitoring, but then others were focused on what kinds of damages can arise to surface waters or to navigable waters should wetlands not be studied. And so we presented that information to the court. Now, what are the predictions on this? As with Robin, I am concerned about the cert grant on this case and what happens if the court rules with a continuous surface water connection test. My hope is that because in Maui, the Supreme Court actually listened to the scientists and they actually developed an additional test called the functional equivalence test of a direct connection to surface waters, that maybe the court might actually listen in this area. Again, I might be a crazy optimist given Maui and the influence that Visa Michi had in Maui, but my hope is that it will go there, right? That they will look at this, they'll remember the 402 program. They'll be like, okay, well, we figured out a test that seemed to work and then we were comfortable with that program. Why not have the same test that applies for both? And we did also try to argue for having some kind of consistent approach to both of these things, because again, the science is still the same regarding connectivity when you're talking about point source permits versus dredge and fill kind of permits. So that's pretty much what I wanted to say, so that there's time for everyone else to speak. But I look forward to talking about this in a more conversational way later. Thank you.
That is great. Thank you so much for that, Steph. And I will now kick it over to Earthjustice's Jannette Brimmer to talk about their role in the advocacy, and then I'll have a presentation as well on Idaho Conservation League's advocacy, and then we'll have time for questions. So Jannette, you're up. You can unmute and go for it.
Awesome, thanks. Hi everybody. I'm really bummed that I'm not there in person, so if there's any people in the room that I know and I would hang out with, hello. And the reason that I am not there, I feel like I'm having echoes in my head, or I have this one-dimensional life, is I am briefing a response to a motion for preliminary injunction in the District Court of North Dakota that was filed by 24 Republican AGs a couple weeks ago. And this concerns the latest version of the rule, which is actually pretty much like the rule that's been in effect since 1986. So why they're all mouth breathing about this now, I got no idea, but there it is. Let's see, I'm going to start with a couple of slides, which really just tell you some of the same things that Steph just told you, but we've got a couple of things that we've been using in that regard. So I'm going to do the thing with the sharing of the screen and all that. So hang on a second. All right. We're going to go to the slideshow. Share screen. Here we go. Cool. Let me see if I can get the whole big slideshow to go.
You're from,
It's not working. Let me do that. There we go. Cool. All right. So this is from the EPA's connectivity report. Hundreds of pages that was done in support of the 2015 version of the rules. And it should be obvious, right? This is like a well duh diagram. But that's exactly how EPA has tried to explain to the courts repeatedly that this is how water works. And it basically is, yeah, like I said, the well duh version of what Steph's clients have said repeatedly to the court. And you can see that waters look very different on the landscape at different times of the year. It does not make them less important. It does not make them less worthy of protection. This is a mapping exercise that Earthjustice did with some professors at St. Mary's University in Minnesota. We picked, I think ultimately it was 9 watersheds. You can see all 9 of them. It's an interactive story on Earthjustice's website. We did this when the Trump rule came out. Now here's why that's relevant. The Trump rule pretty much was based upon the Scalia test from Rapanos. In other words, the so-called, I got to see it flowing on the ground all the time test. The Obama rule in 2015 was more about the significant nexus test. So what we endeavored to do is to show how many water bodies were going to now be cut out of protections with the Trump rule, or the Scalia test, if you will. This watershed is from the Prairie Pothole region of the Dakotas. And in fact, the Prairie Pothole region covers Dakotas, Minnesota, Iowa, Nebraska, up into Canada. And it is where we have had in some regions as high as 90% of pre-white people wetland loss. And so losing more wetlands would be a really, really big deal, obviously, on the landscape. And yet you can see exactly what the Scalia test does to wetlands on the landscape in the Upper James watershed. All of those areas of red are basically wetlands that would lose protections under that relatively permanent test, if you will. And you can see here what they look like. You can see a prairie pothole. You can see a Pocosin from the southeast. You can see peat bogs. All of these are water bodies that are critically important, ecologically critically important, often hydrologically connected, but may very well lose protections if we get a very, very narrow Scalia type reading of the Clean Water Act. I'm going to show you another watershed. This is the Upper San Pedro in Arizona, a watershed that is really, really important to a number of our tribal clients. And you can see that it is just decimated if we go with the relatively permanent test, that all of these ephemeral and intermittent streams that feed the river proper would potentially lose protections. And this is what we're talking about when we talk about ephemeral streams. And they're not just in the desert. The one in the forested picture is a little tiny forested stream in the eastern part of the country, but they can still go dry. They can still be ephemeral, but they are all still hydrologically connected and important. The other one, I think, is the Rio Puerco. Yeah, and that one is in the connectivity report. That's actually an example that EPA uses in its connectivity report. So we're going to stop sharing with that, and I'm going to talk about the specifics of Sackett. We represented, as Cale pointed out, federally recognized Indian tribes. We actually represented 18 of them. They covered all parts of the country, from Virginia to the Great Lakes, to the desert Southwest, to the Pacific Northwest. We wanted the court, we figured there were going to be plenty of people telling the court all of the things that I say in all of my briefs every single time I have to litigate over this rule. I think this North Dakota case is like number 8 or something like that. I don't know. And so we wanted to present a different perspective. We wanted to speak specifically to Justice Gorsuch. And we wanted there to be another voice in the courtroom that was not just, I'm a farmer and I want to plow wetlands, or I'm a developer and I want to fill wetlands, or I'm an environmentalist and, you know, I want to stop the development and save the prairie potholes. We wanted it to be a different perspective. And the tribal perspective was, look, we've known for millennia that waters are connected. We know how critical they are to all forms of life. We rely on these waters for subsistence, for materials for housing, for cultural reasons, for spiritual reasons. Like this is not just, you know, oh, that's a trickle and it's a bother because I want to put a parking lot there. And we pointed out to the court why federal jurisdiction is so important for not just tribes, but in a lot of ways. So tribes have to rely on the federal government's protection of clean water, not just within the boundaries of their reservations, because right now no tribe has treatment as a state for clean water permitting. So they have to rely on the federal government. If the federal government doesn't have jurisdiction within the boundaries of their reservation, then who does? States don't. States can't regulate on a reservation, nor do tribes want them to. So that's a risk right there. But also many, many tribes have rights off reservation. The Pacific Northwest tribes have the treaty right to fish in their usual and accustomed places, most of which is off their small reservation lands. The upper Midwest tribes have large ceded areas where they have retained the rights to hunt, fish, and gather, including activities like wild ricing, which is absolutely water dependent. You know, the Southwest tribes rely on ephemeral waters because that's about all you got down there in many respects. And they rely on them for drinking water. There are sacred seeps and springs in the Santa Rita Mountains that are important to some of our clients. These were all examples that we described to the court, and we described to the court what the threats are to those. And some of the biggest threats right now are mining. Our appetite, particularly for lithium batteries for fancy electric cars, so we can keep driving as much as we have in the past, is being borne on the backs of tribes right now in many, many ways. And so we described those kinds of things to the court. And finally, we said there are legal implications. If you don't have federal jurisdiction, a whole bunch of other federal laws that are of extreme importance to tribes in protecting their waters, even if they're out there swinging on their own, go away. You don't have NEPA protection. Only about, I think, 13, when did I last check on this? 13 states have little NEPAs. So all the rest of them do not. So you lose that entire environmental review if there's no federal permitting. We lose endangered species protections, right? If there's no federal permitting, there's no Section 7 hook. And so you can't do that. And as we discovered in our litigation on behalf of the Menominee Indian tribe in a mining case based in Michigan, the National Historic Preservation Act will no longer apply to protect a tribe's historic and culturally important sites if there is no federal jurisdiction and no federal permitting. So we tried to really emphasize to the court what all of those particulars were. It was an interesting balance. I didn't want to go into too much about how much harm and how many laws might not apply, because with this court, they might be like, cool, we're in, right? So it was an interesting balance in making that presentation. Just a couple of observations from oral argument that I listened to that day. I went in thinking the Clean Water Act was likely dead, and now I'm thinking, well, maybe it'll only be maimed. Maybe. The argument I thought was not as good as Maui. I was fortunate enough to be in the courtroom for Maui when we were on that case, and that you could really see the judges like kind of getting, well, if we're too narrow here, we could really screw things up and people could game the system. And like they were asking all the right questions in that regard. even some of the conservative justices were really grappling with like, well, how do we figure this out? And you can't really do a bright line and, without being on the wrong side either way. Like there was a lot of that you could see going on. There was a little bit of that in Sackett, not as encouraging maybe, but you could feel and hear some of the justices again sort of grappling with the, well, how do you figure this out? And how do you figure it out if it's connected? Some of those were sort of negatively presented, like how is Joe regular homeowner supposed to know that? But also I think some of the justices were understanding like, maybe we do need to give EPA latitude to do these rules because it's kind of hard to figure out. I thought DOJ made very, very good use of Maui in that regard, like kind of reassuring the justices over and over again, like, it's okay. You did this in Maui. You can have a multi-factor test. You can have a thing where it's case by case. Like we know how to do that. Nobody's going to go tearing off and do anything crazy. And I thought DOJ did a very, very good job with that. But maybe Robin is going to be right, which is it's 404 that freaks him out. It's always been the wetlands. And this has become a political thing. I mean, I see that in this North Dakota and the Texas case that we're also in. So 3 cases have been filed against the Biden rule already. Same thing. One in Texas in Galveston, one in North Dakota, and one in Kentucky. And Earthjustice has North Dakota and Texas, and SCLC is doing Kentucky. So I think that what we're seeing in that is it really doesn't matter what the rule is. That the forces that don't like the Clean Water Act are trying to choke it down as much as possible. All of those red states lived with these rules that this current one is based on for decades. In other words, it was no big deal. Commerce didn't stop. Farming didn't stop. Nobody lost their home. People got to do what they wanted to do, right? It's not about that, right? It's not about the Clean Water Act anymore in terms of what the law really is and what the history is. It's all about the politics, and it's all about squeezing the law down to as little as they can probably extract. So I think this litigation will go on for a while. Last thing I want to say, whatever the Supreme Court does, it's about old rules. We have a new one. There's a part of me that wants to say you shouldn't have taken that case. You should have waited until this rule was done and actually got applied to somebody. And then you would actually be ruling on something that is properly before you. Sackett's our old news. We are so many miles down the road from that. There's a part of me that says, I don't know that this is, whatever they do is even going to be all that relevant. Given where we've been and where we're going, but that might also be wishful thinking. So, all right, that's the world according to me at this point.
That was great. That was really phenomenal. All right, I'm gonna switch. I don't know. I guess I'll go share my screen now. See if I can, or I should pull up our slideshow first, right? From the beginning and go right, and then go back to escape, and but go to, all right.
Screen first, and then go to the full screen slide.
All right, so go here. Wasting precious minutes here. All right, and then just go to my slideshow that I see there. All right, share, and now from the beginning. Does that work? Does that work? Sort of works. All right. We lost view of Jannette and Steph, but that's okay. We'll come back as soon as I'm done talking. All right. So I'm going to pick up on something that that Jannette talked about in terms of the others. I say here on the slide, I'll look at the non-water quality values that the Clean Water Act protects. Steph and Robin especially, and Jannette gave you a great look at all of the core water quality issues that you really should care about. I want to spend a little more time on how this ripples out beyond that. but first, before I do that, I think it's so easy for us to forget how much the Clean Water Act, as it has operated, has protected over the years. I mean, it's now a little bit more than 50 years old. The Clean Water Act and I have grown up together. I was a couple months old when Congress overrode President Nixon's veto to put that into law. And so now here we are. This is a photo from a river cleanup event on the Potomac River. And just to give you a sense of what the Potomac River in Washington, D.C. looked like before we had the modern Clean Air Act, I'm going to read you an excerpt from a New York Times story from 1970, talking about water pollution problems in the Potomac. Here's the article. One, I just love the way journalists wrote in 1970. There's just a flavor to the language. You'll be with me in a second on that. The heat of summer is enveloping the nation's capital, and with it has come an annual resurgence of a problem residents have come increasingly to dread, a stomach-churning miasma rising from the Potomac River. Under the bridges that link the capital with Virginia, the 1,500-foot wide ribbon of water is a repellent, opaque gray-brown, so laden with silt, intestinal bacteria, and other pollutants that an official of the Water Quality Agency called it a, quote, severe threat to the health of anyone coming in contact with it. Floating sludge masses lifted by gases of decomposition add to other debris on the water's surface. That was the nation's river before the Clean Water Act went to work. So we have to have a sense of what's at stake just on the water quality side, which is immense. But what's really important, as Jannette hinted at, the Clean Water Act does so much more than that because of the way it's daisy chained together with other statutes. So let me get into that real briefly here. And I'll be sure to save at least, hopefully, half an hour for questions. Maybe 25 minutes. Let's be realistic. So the most obvious hook for how the Clean Water Act looks at other values, national historic preservation values, endangered species values, the most obvious and clean hook is from the National Environmental Policy Act. And what's critical to understand here is that this really was by congressional design. It's not that it's an accident that the Clean Water Act is bringing in these other values. It is intended by the way Congress drafted the statutes. So you go back to the 1969 National Environmental Policy Act, and the idea was, at the time, there were a lot of federal agencies that were approving projects that were environmentally destructive, and those agencies were saying, you know, the environmental issue really isn't our problem. We're the Nuclear Regulatory Commission, or then the Atomic Energy Commission, or we're the Department of Defense, or we're this, or we're that, but we're not the environmental guys, so we don't consider that. And NEPA said, the National Environmental Policy Act said, no, wait, hold a minute. Everyone should at least look at the environmental impacts of whatever it is they're doing. So whenever you have a major federal action that significantly affects the quality of the human environment, stop, draft an environmental impact statement, and assess what is really going on here. Take that holistic view. All right, so the most obvious way that that works is, as you've heard here in the Sackett case, through Section 404. So you need a Section 404 permit if waters, as Robin explained, are jurisdictional, if they fit within the waters of the United States. If they are jurisdictional, then under the regulations to implement NEPA, you've got to look at a whole lot of other effects that are not just water quality effects. You got to look at aesthetic, historic, cultural values, economic, social values. You got to look at cumulative impact. All of that happens. That holistic view that NEPA was intended to trigger happens once you find that these waters are jurisdictional. Let me give you two other examples of where this happens. So it also happens with the Endangered Species Act. Again, as sort of Jannette hinted at a little bit. Under Section 7 of the Endangered Species Act, federal agencies, if they've got a permit that they're going to issue that may impact an endangered or threatened species, they've got to go to the U.S. Fish and Wildlife Service and say, hey, U.S. Fish and Wildlife Service, we'd like a biological opinion on whether this is going to have an adverse impact on this species that we care about. That Section 4.4 Clean Water Act permit triggers that biological opinion. If those waters aren't jurisdictional, you don't have to issue that permit. You don't do that Endangered Species Act analysis. Again, the other picture I've got, so the red wolf picture from Southern Environmental Law Center. Shout out to my colleague in the back of the room who worked on that case for many, many years. The other picture is Montpelier in my home state of Virginia. National Historic Preservation Act. So under the National Historic Preservation Act, you also need to look at impacts to historic properties, again, if there's going to be the issuance of any federal license. So that 404 permit, if the waters are jurisdictional, you're going to look at impact to historic resources. If they're not jurisdictional, that review never happens. Let me give you one really concrete example of how important this is in the real world. So this is, whoops, went the wrong direction. All right, this is an old case. This is a case from 1982, Hoff v. Marsh from Nantucket Island. So a couple of developers wanted to build luxury home with some tennis courts and a couple amenities. They were going to dredge a handful of wetlands to build this development. And they were going to impact in the process a historic lighthouse in Edgartown, Martha's Vineyard, that was of significant importance. And the story of this lighthouse is amazing. It was their original lighthouse was built in 1828. In the 1930s, the U.S. Lighthouse Service said, oh, we need a taller structure than the old one. We want to build a new one. The folks on Martha's Vineyard said, no, this old one is really important to us. We value it so much. So they tried to work out this compromise. They said, okay, you guys like old lighthouses? We'll find a taller, older lighthouse. So they actually moved an 1881 era cast iron lighthouse from Ipswich, Massachusetts to Martha's Vineyard. So people could have the old lighthouse style they liked, but it would be taller, which is what the federal government wanted at the time. And that's the lighthouse is there today. It's sort of this remarkable story. Anyway, the developers were going to develop this land, a small amount of acres of wetlands were at stake. But as it went through the process, the Army Corps of Engineers also looked at historic resources, or rather, the Army Corps of Engineers initially did not look at historic resources. It went to this district court decision which said, hey, wait a minute, under NEPA, under the National Historic Preservation Act, you have to consider the impacts of your development on this really valuable historic resource that people have fought for decades, almost a century, to preserve. Went back and the Corps redesigned the project to make sure that the lighthouse in the new development could live in sync. It wasn't a lot of wetlands at stake in that particular case. I forget the exact percentage. But what is critical to know here, if those wetlands were found not to be jurisdictional, there would have been no federal review at any point that I could see for the protections of this lighthouse. And so that's just one example. There's a case I'm working on right now in Virginia where we're working with a community to protect a historic African-American schoolhouse that was built in 1917 by the Black community, literally sort of pulling themselves up by their own bootstraps, built this school that remained in operation from 1917 to 1964, when the Civil Rights Act finally opened up schools to all children. That schoolhouse now is on land that is immediately adjacent to a proposed landfill. The road of how you get to the school would become the hole in the ground for the landfill. We're able to make the case to preserve the historic schoolhouse to the Army Corps of Engineers because there are jurisdictional wetlands on the site that they want to turn into a landfill. If Sackett says those wetlands are not jurisdictional, we may struggle to get the federal government to look at what's happening to this incredible historic African-American resource in Cumberland County, Virginia. So that's what is at stake. I want to just in last maybe 3 or 4 minutes here, talk about the Sackett case and where I think it might be going. As I said, we represented the UVA Environmental Law Clinic represented the Idaho Conservation League, an amicus brief in this case. Like Robin, I've got a picture here of the Sackett property. This is directly from our brief. And you can see not only how close the Sackett property is to Priest Lake, but you can also see that larger Kalispell Bay fen, that larger wetland resource that is flowing through the Sackett property, divided because of the road, but flowing through clearly to Priest Lake. And the great thing about working with your clients on the ground, your partners on the ground, we got on the phone with the Idaho Conservation League, and they said, hey, we know that site. We've been to that site. And let me tell you something, right above where the Sacketts, farther away from Priest Lake, where the Sacketts have dredged this property, there are trout spawning habitat. We know that there are trout swimming from Priest Lake up the channel to the wetlands, spawning and then coming back. I mean, we have really clear evidence that this is an aquatic resource inextricably intertwined with Priest Lake. So, we got that great story from our client that's also reflected in the administrative record for the case. The question now is, as we sit and wait, like Jannette and many others, I listened to oral argument in this case. A few things stood out to me that I want to share with you from the oral argument on the case. So one question that some folks had is, what about, West Virginia v. EPA, the major questions doctrine, is this new sort of gloss that sort of getting ready to potentially throw out Chevron, certainly sort of put Chevron in a little box in the corner. Is that going to sort of have a role here to play? To be honest, I don't think so in this case. I was sort of going back through the transcript from oral argument. Justice Alito at one point referenced sort of the clear statement rules, meaning major question doctrine and others, and to see whether they would have a role here. And Justice Kavanaugh picked up on it a little bit when he said, well, this is a quote from the oral argument, why not let Congress figure out where the line is? In other words, let Congress rewrite the statute to address what the waters of the United States actually covers. But other than those two very brief mentions, I didn't see a lot about clear statement rules or major questions doctrine come up in this oral argument. What I did hear was at least four justices, Kavanaugh, Barrett, Kagan, and Sotomayor, get to an issue under Section 404G and adjacent wetlands to waters that states are prohibited from regulating. So there's a class of federal waters that are exclusively federal. States can't regulate them. And wetlands adjacent thereto, using the language from the statute, are also federal only. So Justice Barrett was really keen on this point and saying, wait a minute, if we've got wetlands that are adjacent that can only be federal, and then you're telling me wetlands adjacent can't be federal because they don't have that surface water continuous connection, then no one can regulate them. States can't regulate them and the feds can't regulate them. And at one point she said to the counsel for the Sacketts that 1444 or 1344G is the biggest problem for you, clearly. So I think she was really troubled about this donut hole involving adjacent wetlands. So that was the piece that gave me the most encouragement. The quote that gave me the most worry was from Justice Sotomayor, where she said to the government's lawyer, she said, so is there another test, not the Rapanos test, not the adjacency test, not the significant nexus test, but is there another test that could be more precise and less open-ended than the adjacency test or the significant test that you use? And she concluded, is there some sort of connection that could be articulated? So clearly she knows that, or she suspects, just sort of reading into her language here, that she doesn't have the votes to save the significant nexus test. At least that's how I read that statement. And she's looking for another way to do it, just the way that Justice Breyer looked for another way to do it in the County of Maui case, and he wrote the majority opinion there. So in that sense, I agree with Robin that I think we're likely to see some new test, not the significant nexus test, not the Rapanos test, but whatever test they adopt, we know that there is so much at stake, not just Clean Water Act values, but a whole world of environmental values. So with that, I'll stop sharing, and we've got 26 minutes for questions. And I've got two I see in the Q&A already. Oh, no, that's just, I'm sorry. Apparently Zoom participants could not see slides, but hopefully they were able to follow the brilliant back and forth dialogue among the panelists. All right, yes. Greg.
Thanks for doing that. And I know that there's a group of environmental law students in here who are going to be much better prepared for your focusing water midterm question next Wednesday. I just wanted to, several of you referenced the idea that there could be this new test. It's not Scalia, it's not Kennedy. But no one really dared articulate what such a test might be. So I not as a projection, but just if you have the ability to come up with the ideal test that would replace the Sackett, what do you go with?
I'm going to jump in here. Since the functional equivalence test was adopted in Maui, it'd be a nice analog to this, right? If there are all those connections that they outlined in Maui regarding like subsurface connections,
Hold on a second, Steph, let me, I've
they
left
can do a
this.
similar kind
There we
of
go.
what?
Sorry,
Oh.
that was a great observation. Did I lose you? Damn it.
No, I'm here. I'm here. Wait,
Where
what?
is it?
On the bottom.
Oh, I see it there.
What?
Hold on, you're still there, I hope.
I'm
You
here.
never put me in charge of a screen.
I'm confused. I'm here.
All
I
right,
see.
there we are. All right.
So
So,
sorry.
yeah, no, Steph's point about the functional equivalency test from Maui, that was, I don't know if you want to restate that point or,
So Maui adopted the functional equivalence test of a direct discharge into surface waters, even if it wasn't technically directly into surface waters. And it looked at a bunch of scientific principles. And I'm really, yes, this might be overly optimistic, but I'm hoping that they will do something like that there based on the various features that we outlined in our brief. That would be great because it would make 404 and 402 much more analogous in terms of the approach to science. And that's really what all the scientific community are asking for, is just make it make sense scientifically.
Robin, do you have a guess?
I have no guess. Well, I do have a guess. I do not have a perfect test, but I actually think they're going to use this case to separate the permit program. So you're going to use Maui 402, which broadens that up. They're going to come up with a very Scalia or even worse test for 404. That's my prediction. Because I like I said, there's a long history of they want 402 to be as broad as possible, and they hate 404, and that's been true through several courts now. So it's not my perfect test. My perfect test, I'm with Justice Stevens, the limits of the Commerce Clause. But I lost that one a while back. So
Yeah, Jason in the back.
There's ample statutory grounds to decide this case, but do you think the court might take the opportunity to say anything more about the major questions doctrine?
So my thought was, no, I went back through the transcript before coming out here. I only saw two references to it. One from Justice Alito, one from Kavanaugh, but both were pretty small. Maybe Alito cares more about it in raising it, hopefully in a dissent. I think Kavanaugh seemed to, the one thing that gives me hope about Kavanaugh in this case was he was going back and forth with Sackett's attorney and was asked, was asking about the Rapanos test and said, well, look, the last 7 presidential administrations, including the Trump administration, agreed that that was too restrictive and included at least wetlands that if they were separated by a man-made berm or road or structure like that, that could still be considered sufficiently adjacent to be jurisdictional. So, I mean, what I worry about is that you've got this property, as Robin explained, that's super well connected and seems obviously jurisdictional, that they sort of use that to say, the environmentalists win this case, but they're going to lose the war because we're going to draft a very restrictive test that lets properties like this remain jurisdictional, but excludes a lot more based on the slides that Steph showed. I don't know, Jannette, do you want to add on that?
On the major questions thing, I mean, I agree with you, Cale. They're not, I don't think they're going to go there because I am briefing that right now on the Clean Water Act. They are, when you read the West Virginia case and all of the reasons that the court gave for why they were stepping in there, it's so different. Like the Clean Water Act is so different. They're, you know, the agencies aren't striking new ground. I mean, they've been regulating these waters for decades. There's, you know, it's been up to the court multiple times, and the court has said, you know, look, you can get at adjacent wetlands, and that the Clean Water Act should be read broadly. And so it's just not, it doesn't fit into that major questions box. Now, if the court did do something with major questions here, then you know it's a free for all, right? Because it doesn't really otherwise fit in that. And other than that, yeah, it's just tea leaves. I also know, like, I mean, we're starting to get opinions from the court, so we've been signing on, and I haven't seen anything yet, but you know, it'll speed up here soon, probably.
I mean, I just don't see how they can square using major questions doctrine in this case, given Babbitt versus Sweet Home, which is also about development, right? That greatly expanded what the reach of the Endangered Species Act is to sort of basically development. And that's what's at stake here. You know, it just really doesn't make sense to me. So that's my point.
Yeah, and I'll just agree with Jannette that if this becomes a major questions doctrine case, everything's a major question. The agencies have been deciding what are waters of the United States since the 1970s. So it's something that everyone has agreed is clearly within their bailiwick, it's suddenly not. All bets are off.
Yeah, in the back.
In listening to the argument, I felt like the vibe was, okay, we get it about how water works, but it's just not fair to property owners to have to wait around for a determination. And it felt to me like there would be some desire for a test that would give immediate certainty upon purchase of property, or you know, so that what's in play here is a redo that's in the conservative majority's view, helping out property owners who for the last decades have been in a bind. And I'm just wondering if those of you who are closer to this felt that thread of the case as strongly as I was as a passive listener, and where you feel it can lead for the new rules that the Biden administration is saying.
So Abby, I'm going to jump on that, and then I'll let, I don't know if Jannette wants to talk on it as well, or anyone, but in this, again, is wonderful piece about getting to work with the Idaho Conservation League and hearing the story. So the Sacketts were, you know, they're not sort of just innocent homeowners who didn't know that the Clean Water Act was there. They got into they have a construction business. So they deal with these kind of permits all the time. And there's definitely a flavor of trying to tee this up as a stalking horse. What we noted, and again, the Idaho Conservation League folks were the one who went to the local Army Corps of Engineers office to get us the data on this. And we cited this in our amicus brief. This property was actually a pretty easy call on jurisdictional grounds, and it didn't have to take, you know, 12 plus years of litigation to sort it all out. Likely under the existing Army Corps rules, this would have been qualified for a general permit quick review. In other words, the amount of wetlands were less than half an acre. So they didn't have to go through this long, expensive, burdensome review. We found some permits issued by the same Army Corps office that would review this case, who had issued permits under the general permit guidance in a matter of a couple of weeks. So they could have been in and out of this in one summer easily. They chose to litigate it, I think, in part because, you sort of see this a lot from opponents of environmental safeguards, that when the rule is, oh, we need to protect the environmental resource here, the response is, well, the rule doesn't seem very clear to me. And the rule is somehow only clear when it rules out protecting the aquatic resource or the environmental resource. So I think that's what's going on here, that this was a pretty clear case, frankly, of jurisdictional wetlands. I don't think there was that confusion. I don't know if Jannette or Steph or Robin, you want to jump in on that question?
Well, Cale, didn't they also have an earlier jurisdictional determination? I think that the facts were that the Corps had determined this property was jurisdictional, and JDs last for 5 years. And so it had expired, but the environment doesn't expire, right? Like, I mean, it was still obviously jurisdictional. These guys, you know, so any argument about confusion, but Abby, you're right. And I'm not just saying that because you're my boss and I want to. You're right, though. I mean, that comes up all the time, and it came up in argument, as you note, which is like, what's a poor homeowner to do? Gosh, all this science, and how do they figure it out? And I thought that was just a trickle. And one of the things that I found heartening is one of the justices, I don't remember who, said, well, can't you get a free jurisdictional determination from the Corps? Like you just go ask them, right? Like if you're not sure, you go ask somebody and they'll tell you. And that we've been saying that a lot, but I think that's a danger. I think it's one of the ways they feed what Robin pointed out, which is that they hate 404. And one of the ways they feed that is farmers can't farm, people can't build their dream home. This is, you know, the jackbooted thugs overreaching, and now they're coming onto your property and telling you what you can do. And that is always really hard to overcome. So I am worried that plays in the back of their minds, even if it's not overt, like in questions or in their writing.
Can I just jump in really quickly and say hat tip to you, Jannette, because you haven't mentioned this the whole time, but Amy Coney Barrett really asked a lot of detailed questions about like tribal, you know, water protections, and it was your brain like ever that I think you really influenced her line thinking about Rich.
We lost a little bit there from the end of
Oh,
Steph's
sorry, I
remarks.
just want to give kudos and have everyone hear kudos about Jannette's great influence in that area.
Yeah, no, absolutely. And sort of bringing the tribal issues seem to clearly resonate with at least a portion of the court. Yes, in the back.
I wanted to follow your potential worst case scenario of the court overturning the other side. What would the consequence of that be? I'm just trying to imagine if there would be no adjacent section at all, or like the bravado of the Supreme Court precedent. I mean, what authority would they have to do that? And then what would happen when they require Congress to amend the Clean Water Act? Or just trying to figure out like, what would that look like, and or if they really came 404, thinking that would be what they want to do. And
Right.
how would that affect the Biden rule if they were to do that? Or what?
Okay, well, the Biden rule to me hangs on the thread depending on how this decision goes. So, it would be nice if they would just defer to the rule. They haven't done that for quite a few rules now, so I'm not holding my breath for that. But if they overrule Riverside Bayview, you do have still 404G that you have to deal with. The adjacent wetlands are explicitly mentioned in there. So I think at that point they would have to get into more technical definitions of what is meant by adjacency. But to the larger part of overruling Riverside Bayview, to me, would be overruling any sense that the agencies have expertise and that this is a hard question. That a quest for certainty when you're dealing with waters is just, it's a fool's errand. You're not going to have absolute certainty at all times about what is and is not connected until you've done all the studies that need to be done. So I think that would be the broader implication of it. If they did that, that's not what I predict, but they were in a mood, so who knows? But if they did that, yeah, then we should have been back in Congress way back at Rapanos. I mean, the minute you get that kind of split out of the Supreme Court, we should have Congress saying, oh, and by the way, waters of the United States means, and there were a couple of proposals just to put in the 1986 regulations of statutory language, which would have solved not everything, but most of what we're getting into. And that's the other side of this, is that this has become a battle between landowners, the court, and the agencies, with the kind of where the buck stops, and part of our government that could just end it, not choosing to intervene. And so, you know, the fact that we've had a circuit split on a national statute that should be applying even-handedly across the United States. We've had a circuit split for 20 odd years, well, not 20 odd, sorry, but 15 odd years now, 17 years, with nobody stepping in to fix it is criminal. And I think making it more uncertain is the absolute worst thing the court can do. So.
Before you go to you, Jim, I just one other point about Rapanos that that we argued in our amicus brief that I think is important to share. I mean, sorry, not Rapanos, about Riverside Bayview homes, is that, you know, the famous phrase from that is that it's hard to, you know, to tell where waters end and land begins. And critics of Clean Water Act jurisdiction have used that phrase to say, oh, that's like a physical test. In other words, if I'm walking down the shore and my shoes are wet, then now I'm in the water. And if I step back a little bit and it's hard to tell, there, maybe it's a little squishy, maybe my toes are wet, I can't tell where it started. That's not really what the court was talking about in Riverside Bayview homes. The property was actually pretty far from Lake St. Clair near Detroit. It was right on the edge of a man-made ditch that flowed into Black Creek. Black Creek was itself navigable. You could put a canoe in it. And then Black Creek flowed to to Lake St. Clair. So it was pretty easy to tell where Lake St. Clair ended and the Riverside Bayview homes property began, because they didn't touch each other. They were separated by this ditch and then by Black Creek. So what the court was really talking about in that moment, if you go back into the history, and I had a UVA clinic student go back into the oral argument, Riverside Bayview homes, to help us understand this. What they were really talking about was it's hard to tell where the hydrological connection ends and where it begins. And that it's the hydrological line between land and water that's tough to tell, not the physical line. Anyway, so I think that's really at stake if they throw Riverside Bayview homes out.
Can I add something to this too? The court has recognized that there are differences, that technical differences between what our ordinary understanding of things is versus the actual scientific understanding of things is. Like, for example, RCRA, solid waste. But solid waste in RCRA are sludges and a bunch of other things that are slurries. They're basically analogous to all the mushy materials that we're talking about. So I just wanted to sort of just emphasize it. Departing from the layperson kind of perspective on solid liquid water is not unusual for laws and has been accepted in other contexts.
Jim?
Yeah, I'd like to, Robert, you could kind of expound upon your predictions that they might set right up 402 and 404, because the statute is not structured the way that it allows that. Obviously, you know, the opponents of clean water have been bringing 404 cases because they touch into a lot of the things that we're talking about in terms of, you know, for what everyone wants to swamp. And, you know, it gets more in the way of development, et cetera. And I think people want this really get, you know, dumping something nasty into a stream. Do you think they will actually come out with two tests, or do you think they'll do that? I think that they lead into that, or Rapanos of, well, you know, ditch that's carrying nasty stuff that's cleared out into the water could become a point source to regulate.
Yeah, I think it's more that, if you look at the 404 case and the way the significant nexus test is being applied, including in Sackett, you're not analyzing whether the pollutants added to the wetland make it to the truly navigable water. You're analyzing whether that has an ecosystem effect of some sort that is going to affect the integrity of the downstream water. And while I agree that that fulfills the Act's goals, because it is chemical, physical, biological integrity, a court who wanted to could pick up on, okay, Scalia definitely never ever seen a dredging operation, but his idea that, you know, you dump the stuff in the wetland and more or less stays there, doesn't flow downstream, well, in the context of the Maui decision, which says, hey, at functional equivalent, anything that actually gets pollutant to the downstream water is good enough for us, to create a not necessarily a legal distinction on paper, but a practical distinction in how it would play out on the ground. That if what you're doing is filling the wetland, but not much actually makes it downstream, it's going to be non-jurisdictional, whereas if you're in the NPS context, 402 context, actually shooting pollutants in a liquid form out into the world and they're making it downstream, they would be included. That's how I'm envisioning that one playing out.
All right, any other questions before we wrap up? Anyone on the online have a, Steph or Jannette, have a final comment you'd like to share before we close it out? Guys?
It's killing me. I'm not there and about to go drink beer with all you people. That's all I got to say.
Yeah, I wish I
That
could.
is
be there too.
all
Sorry.
the richer to drink because of the clean water protections that went
But,
into making good beer.
That actually brings into play the most targeted amicus brief I've ever seen, which was the Colorado amicus brief on this case, where they actually go on and on about how this is necessary for the protection of water,
All right. and
which I read as like totally like as Kavanaugh.
So-
at Kavanaugh. So it was kind of hilarious to read.
So that's our reading going forward, is we all have to go find the Colorado amicus brief, read that while we're having a craft beer, not from Colorado, but from Oregon, because we're going to be loyal to PIELC. So thank you, Jannette and Steph, for being online. Thank you all in the room. That was a lot of fun.
Bye.